Today on Bench Briefs, we're looking at a landmark decision from the Supreme Court of Canada that tackles a fundamental question about democracy and rights. Should prisoners lose their right to vote? This episode dives into the 2020 case, Fraser v. Canada Attorney General, which challenged the ban on voting for certain incarcerated individuals. At its heart, this case is about the right to vote, a cornerstone of Canadian democracy protected by the Charter of Rights and Freedoms. The Canada Elections Act prohibited prisoners serving sentences of 2 years or more from voting in federal elections. Mr. Fraser, who was serving time, argued that this ban violated his charter right to vote under Section 3. The Supreme Court had to decide whether denying voting rights to these prisoners was constitutional. Let's start with the key facts. The appellant, Mr. Fraser, was incarcerated and wanted to vote in a federal election. However, the law at the time barred prisoners serving 2 years or more from casting their ballots. This wasn't a new rule. It had been part of Canada's election laws for years, but it hadn't been challenged at the Supreme Court until this case. Fraser argued that this prohibition infringed his democratic rights and was therefore unconstitutional. The government defended the ban, saying it was justified because prisoners had broken the social contract and that restricting their voting rights served important objectives, like promoting respect for the rule of law and civic responsibility. Essentially, the government claimed that losing the right to vote was part of the consequences of serious criminal conduct. So, what legal questions did the Supreme Court have to answer? First, did the ban on voting for prisoners serving 2 years or more infringe Section 3 of the Charter, which guarantees every citizen the right to vote in federal and provincial elections? The court unanimously agreed that it did. The right to vote is fundamental and cannot be taken away lightly. Next, the court had to consider whether this infringement could be justified under Section 1 of the Charter, which allows reasonable limits on rights if they can be demonstrably justified in a free and democratic society. This involves a test to see if the law's objectives are pressing and substantial, and if the means chosen are proportional and minimally impairing of rights. The court found that while the objective of encouraging respect for the law and civic responsibility is important, the ban was not a reasonable or justifiable limit on the right to vote. The prohibition was overly broad, affecting a large group of prisoners regardless of individual circumstances or the nature of their crimes. In other words, the law was a blunt instrument that unnecessarily stripped voting rights from many people without sufficient justification. This ruling means that the government cannot deny voting rights to prisoners serving sentences of 2 years or more simply because they are incarcerated. The court emphasized that voting is a key part of civic participation and rehabilitation, and that disenfranchisement undermines democratic values and the reintegration of offenders into society. Why does this case matter? It's a powerful affirmation that the right to vote belongs to all Canadians, regardless of their circumstances. By striking down the ban, the Supreme Court reinforced that democracy must be inclusive and respect the dignity and rights of every citizen, even those who have committed serious crimes. The decision also signals that laws limiting fundamental rights must be carefully scrutinized and justified with clear, compelling reasons. This case fits into a broader global conversation about voting rights for incarcerated individuals. While some countries restrict prisoner voting, Canada's Supreme Court has now set a clear standard that such restrictions require strong justification, and a blanket ban simply doesn't meet that standard. Thank you for listening to this episode of Bench Briefs. Join us next time for another deep dive into the cases that shape Canadian law and society. Until then, stay curious and informed.